The Commonwealth is correct that a concurring opinion in Bruin did state that the ability of states to require a license is not affected, but the holding in Bruin basically took away all subjective criteria for issuance of such a license. The Commonwealth points to no historical precedent limiting the reach of one's exercise to a federal constitutional right to only within that resident state's borders. While the Supreme Court did have a concurring opinion that state licensing requirements were not affected by its decision, that was only the arbitrary decision of one of the justices on the court, unsupported, by the way, by the Constitution of the United States. Even so, what right does the Commonwealth have to limit the exercise of a constitutionally protected right? How can the Commonwealth claim to be giving full faith and credit to the public acts of another state if they provide such an arbitrary exception for carry licenses? Moving on to the defendant's claim that GL 269 Section 10A violates the defendant's right to travel and equal protection. The Commonwealth also asserts that it does not violate the right to travel and equal protection clauses because the Commonwealth's license requirements do not prohibit him from traveling in Massachusetts. They only prohibit him from carrying a firearm while traveling in Massachusetts. The Commonwealth further argues that the licensing requirements don't treat non-residents differently than a resident because they can apply for a temporary non-resident license to carry, or they can travel through the state while complying with statutory exemptions of unloading the firearm and storing it secured in a locked compartment, and the travel is for a specific purpose, such as training or competition. Personally, I think the right to travel and equal protection claims are the weakest in this case. As the Commonwealth points out, defendants were free to travel in the state as long as they complied with state law, and they could have carried firearms if they had obtained a state license to do so. However, while these points may be the weakest, the court still upheld them. The Commonwealth's argument against the defendant's claim that GL 269 Section 10A violates his rights under Equal Protection Clause because he can obtain a temporary non-resident license to carry is also unpersuasive. As stated above, prior to the Bruin decision, Massachusetts treated the carrying of a firearm as a privilege. While it allowed non-residents to apply to obtain a license for that privilege, non-residents were not treated the same as residents. Residents of Massachusetts obtaining a license were granted the license for 5 years. A temporary non-resident license was valid for 1 year. The court points out that a resident and non-resident license were not equal, since a non-resident license is only valid for 1/5 of the time a resident license is. But what about the licensing scheme as a whole? The Commonwealth next argues that Massachusetts' licensing scheme imposes a permissible burden because of the substantial state interest in preventing certain people from possessing firearms. However, under federal law, certain people are prohibited from obtaining or possessing firearms, makes it unlawful for certain categories of persons to ship, transport, receive, or possess firearms or ammunition. The problem with this Commonwealth argument is that Massachusetts does not use its licensing scheme to prevent certain people from possessing firearms, as the law clearly states. It permits, by exception, certain people to carry firearms. Since New Hampshire requires a background check to be issued a carry license, Massachusetts should have been satisfied that said certain person would have been denied a carry license in the first place. While Judge Kofi uses a federal law to make it unlawful for certain categories of persons to possess a firearm, that law itself has constitutional issues, since public safety is a state power, not a federal one, under the 10th Amendment.